Hi, I'm JDE Eisenberg with the JDE Law Firm. I'm a business litigation attorney, which means that my business is to protect your business. Today I want to talk about mistakes that people when drafting a contract make. And I'm going to be using recent experiences to kind of show what to do and what not to do. But first, I just want to say that if you have any questions about what you're going to hear today, or you just want to discuss your business, or you think you might have a potential case, all you have to do is go to meetjde.nyc, meetjde.nyc, and you could book a 10-minute phone or a 30-minute in-person consultation with me. Now, common mistakes when drafting a contract. There's been a few recently that makes me want to just jump on, because as a business litigation attorney, I'm the one you go to when there's mistakes in drafting a contract that leads to issues. Now, the first one that comes to mind is there was a sale of a business, and the sale did not actually go through. My client wanted to go after the damages because the sale did not go through, or they wanted to enforce the deal. So I read through the sale papers, the contract, I should say. In the contract, what they said was that you can cancel at any time, even the day of the closing, and it was absolutely silent on any kind of penalty clause. To me, that is utterly ridiculous. Okay? You need a penalty clause when you're selling anything if the sale doesn't go through. Liquidated damages, just something to say that if you fail to go through with the contract, there is a penalty. Second, by letting them back out at any time for any reason, how could you sue them? You can't. It was obviously not drafted by the seller's attorney, but it wasn't reviewed well either. So my client cannot do a single thing that I can think of to actually enforce that contract. So he's out of luck. 2, this is another mistake. They put in a contract, it was a different kind of contract, but it was an agreement where they agreed that there would be a list of issues that they could then, if there was any issues with the list of issues, you could mediate or arbitrate, do something else. The contract actually just said that each side will provide their own list of issues. Again, utterly ridiculous. You cannot have such an open-ended agreement, because then you could throw anything in there and all of a sudden it's an issue. I'm trying to make sure that's in the camera. It's an issue. You could say, the sky is red. This is an issue, we have to mediate. Just the open-endedness without defining it prior to signing the agreement. You can say, no, this is not an issue, I want to mediate. This is not an issue, let's resolve it some other way. But just leave it open-ended that you could then draft anything you want on a piece of paper, say, now this is on the issue list. I would never have done that in a million years. So those are 2 major ones I've thought of, that I've come across recently while looking at it. There's a third one that has come across. It was actually in the same one as the issues list. What it said in there was basically it was over a sale. If they fail to complete the sale price, or they don't want to pay the extra amount, they'll return the business to the person who sold it. Problem is, and I'm leaving out a lot of details on purpose here, but the problem is if you make that decision, if they make that decision where they just want to return it, they don't want to pay whatever, let's say it's $2 more million the client's going to be owed, and they don't want to pay it, they say, here you go. Well, now they've actually, and again, I'm leaving out details here, but they actually are, they've had the business for years. If they've destroyed the business and make it worth 0 and say we don't want to pay you $2 million, well, now according to the contract, my client gets a business worth 0 instead of the money he's actually owed. There was no protections to go along with that provision. So when you're drafting a contract, so you don't end up in litigation, you need to protect these kind of things. If you're going to say that the business gets to be returned, but it has to say at the value it was at on X date, something along those lines that protects it, so you have a number there. Okay? So you're not getting a business worth 0. So I've just named three very specific examples of mistakes that are made when drafting a contract. Okay, and this shows that these contracts were not drafted by contract attorneys. and they are in litigation or will be in litigation. To prevent this, you need to not make such egregious mistakes. You need contract attorneys, okay? So, just always remember that, I do this a lot, I'm sorry. Change of thoughts. I'm Jesse David Eisenberg at the JDE Law Firm. My business is protect your business. And if you'd like to discuss anything you heard today, you can go on to meetjde.nyc and you can book a 10-minute phone or a 10-minute phone or a 30-minute in-person consultation. Thanks for watching and listening.